Greetings, family, and welcome to another edition of KSOL Black Talk Radio, the new black media. Today is Saturday, December 23rd, 2018. Family, this video is about the 50 years of the Stop-and-Frisk. It's a retrospective of the Terry versus Ohio case. Now, for those of you who are following and don't know what the word retrospective is, let's take a look at exactly what that means before we move on. The adjective of retrospective means looking back on or dealing with past events or situations. The noun means it's an exhibition or compilation showing the development of the work of a particular artist over a period of time. We're going to deal with the first one, the adjective of looking back on or dealing with past events or situations. This retrospective is done by two people by the name of Patricia George and Alexander Ben-Ezra. Let's take a look at who these people are before we get into exactly what this study has revealed. So this first person, Patricia George, is the Assistant Bureau Chief of for Community Prosecution at the City of Phoenix Prosecutor's Office. She has been with the office for 17 years. As part of her duties, she currently oversees the Prosecutor's Office management for the Phoenix Veterans Court, Phoenix Behavioral Health Court, and Misdemeanor Repeat Offender Program, and she is the Prosecutor's Office liaison for homelessness issues in the city of Phoenix. This second person is Alexander Ben-Ezra. Alexander Ben-Ezra has been practicing in the field of criminal defense since 2010, currently at the City of Phoenix Public Defender's Office. He also serves as the treasurer of the State Bar Criminal Justice Section, a member of the Arizona Supreme Court's Post-Conviction Actions Task Force, and is the president of the Arizona Thurgood Marshall Inn of Court. These are the two people who conducted this study. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. In the early afternoon of October 31st, 1963, on a quiet sidewalk in Cleveland, Ohio, John Whittle Terry and Richard D. Chilton drew the attention of Detective Martin McFadden. The interaction that followed led to a case that created ramifications for law enforcement, prosecutors, defense attorneys, and communities over the next 50 years. On that Halloween day, McFadden observed Terry walk from the corner where he had been with Chilton and make a slow pass in front of a business, United Air, and then return to the side of Chilton, who would then proceed to make the same slow pass. After completing about 3 passes each, they went back to the corner and met a third man, Carl Katz. Based on the detective's 30 years of experience as a robbery detective, he determined that the men were acting suspiciously and believed they were casing the business for a robbery. McFadden stopped all 3 men and searched them for weapons for his own safety. He found both Terry and Chilton to be in possession of illegally concealed weapons. During the court proceedings, the facts as presented indicated that the detective patted down each individual and did not reach into the clothing of either man until he felt the shape of the weapons and determined there to be weapons concealed on each man. That interaction led 5 years later to Terry versus Ohio. Out of this 1968 case, the quote Terry stop or quote Terry frisk created the ability for officers to initiate a stop that did created the ability for officers to initiate a stop that did not rise to the level of probable cause required under the Fourth Amendment, yet was still both a stop and a seizure. And if you recall, family, before I started this video, I read the part of the Fourth Amendment. So, yet this was still both a stop and a seizure. So, prior to Chief Justice Earl Warren's decision, no distinction existed between the stop and frisk and searches and seizures. The probable cause standard stood for all varieties. And before I move on from this point, this reminds me of right now, today in 2018, moving into 2019, where they have now made it possible for the police to come under the law of stand your ground. This was the manifestation of that. I find this very disheartening for our democracy, because once again it shows how unfair and one-sided, and furthermore how racist this system truly is. When you can target certain individuals based on a law that you came up with, a system that to many is considered not only unfair but just downright evil, well, there's a problem. And there's going to always be a problem when there's injustice. If you really like Martin Luther King, as you always seem to quote his "I Have a Dream" speech, you should also remember his other quote about injustice anywhere is injustice everywhere. I know I paraphrased it and I chopped it up, but you get exactly what point I'm making, I'm sure. But I digress. The issues that the Supreme Court examined in Terry did not occur in a vacuum. As society changed throughout the 1960s and unrest began to take hold, several events led to the stop and frisk issue coming to the Supreme Court. Officers had been stopping people to question and frisk them for several decades leading up to the 1960s. As many of these did not result in arrests or the collection of evidence, the constitutionality of these encounters did not receive an examination, and they should have. Ultimately, state legislatures began to focus on the practice. Some codified the stop and frisk as legal. New York was one of those states. It enacted a law to authorize the police use of stop and frisk maneuvers. As more states realized the value of this strategy as a tool to combat crime, the American Law Institute drafted a model code of pre-arraignment procedure in 1966, and President Lyndon Johnson's Commission on Law Enforcement and Administration of Justice encouraged states to enact provisions granting law enforcement to the authority to employ stop and frisk. So basically Lyndon Johnson, him and his administration, they of course backed this stop and frisk law. As this issue came to the forefront, several cases began to appear. Before the Supreme Court's Terry's decision, the court ruled on a stop and frisk case arising from New York, the Cybron versus New York. That's Sibron versus New York. Ultimately, the court held Cybron along with a companion case, Peters versus New York, and upheld the state's law in a decision published the same day as Terry. While Cybron and Peters interpreted it state law, Terry became the Supreme Court's basis for interpretation of the Fourth Amendment as it applies to stop and frisk. So, in other words, they used some shenanigans to make stop and frisk legal. That's what that means. They used shenanigans to make stop and frisk legal around the Fourth Amendment. In other words, they kicked the Fourth Amendment in the behind, and they skirted and skated around that amendment. This is what white tyranny looks like. It's what white tyranny sounds like. It's what white terrorism really is about. It's about using shenanigans to skate around things to make it hard for certain targeted groups. That's what racism is. I'm making it very clear what this is. Very clear. But I digress. Today, people are familiar with the Terry frisk and the ramifications that this landmark search and seizure case and its progeny can have from either the prosecution or defense perspective. To be clear, a frisk is a search and can lead to a seizure of evidence that may be used against an accused. To better understand Terry's nuances, though, it is important to take a look at the current state of Terry in Arizona and the adoption of the plain field doctrine. So I looked up what the plain field doctrine is. So I looked up the plain field, that's plain, P-L-A-I-N, field, F-E-E-L, the plain field doctrine, and that is where an officer is allowed to pat down a suspect and may only remove items identified through the plain field of the items as identifiable as contraband or dangerous items. State versus Premios. Now, what that means is that officer who pat down the three men previously who I spoke about, when he felt that they had a firearm because of that pat down, he was able to then seize their property, and thus skating around the Fourth Amendment. So Terry and its associated cases in Arizona establish that a police officer does not violate the Fourth Amendment's prohibition on unreasonable search and seizure if the officer stops a person and frisks him or her without probable cause, as long as there was reasonable suspicion that the person is committing, had committed, or was preparing to commit a crime, and that there is a reasonable belief that the person may be armed and dangerous. That's exactly what I just said, and there it is, right there in print, saying exactly what I was saying. Under State versus Garcia, officers must show that there is a articulable reason. And I laughed at that word when I read that, articulable reason. Articulable, that you're able to articulate. Okay, for the officer to fear for his or her safety, and further, under State versus Premios, that this articulable reason was determined to be, quote, based on the totality of the circumstances, unquote, thereby justifying the seizure as lawful. Again, when you have a system set up that is not about justice and you make the rules, your rules are just as unjust. Therefore, you have an unjust system based on a bunch of rules that you call laws, yet they're unjust. Very interesting dichotomy, but I digress. Now check the other trick. The main shift after Terry is that the focus is on officer and public safety, not necessarily that there is a particularized reasonable suspicion that the person being searched is committing or has committed a crime. Yes, now they've changed the narrative so that they could justify their evil or very unjust system. Again, these are shenanigans, just like I stated earlier. But moving on. Now, while several cases examine exceptions to probable cause and Fourth Amendment requirements, the most important result from these cases is that officers cannot simply perform Terry frisk as a matter of routine. They must follow the requirements set out in the Terry line of cases. Now, we know that the police do not follow even their own rules. They break the law all the time, and yet they call it legal for them to justify arresting you, as long as you are a black person, man or woman, particularly if you're a black person. As an interesting comparison, many state legislatures have adopted statutes to clarify when officers may stop a person prior to establishing a probable cause. The most common extension is known as, quote, stop and identify, unquote, statutes, which 24 states have adopted. A person must, at minimum, identify him or herself, although states expand on that concept in different ways. Arizona is one such state, which requires a person to state his or her truthful name to an officer if stopped with reasonable suspicion that the person has committed or is about to commit a crime, and the officer advises the person that failing to provide his or her truthful name is unlawful. The statute specifies that a person may not be compelled to answer any additional questions. Violating this law is a Class 2 misdemeanor. Before moving on, you know they always say that a picture is worth 1,000 words. It's so funny how in this picture you see a black officer and what looks to be a Hispanic officer or Asian officer, and they're looks like they are trying to talk to or arrest these or pat these. Looks like they're stopping and frisking these two, is what it looks like. And isn't it funny how the individuals, the spectators on the side, they're like really on the black police officer for having the white dude held up against the wall. They're not even paying attention to the other guy, the Hispanic or Asian officer holding up the black man. They're more concerned with how the black officer is holding up the white guy. That tells you a lot, though, of how racist our system is and how normalized they're used to seeing black people getting arrested and jacked up all the time. They're so used to that they get mad when they see a black officer doing it to someone who looks or appears to be white. But I digress. When examining the nation as a whole, states have adopted various approaches, both of what officers are allowed to do when approaching people and in their adoption of statutes. Some states have addressed the issue by statute, some by case law, and others have left it to individual counties and cities. Now, when we are called the United States of America, United States of America, and we're so divided, I find that name very insulting and offensive, number one. But it also goes to show that in each different state and city and county, just like this article points out, we have all these different laws and different things for different people. And it's all to appease this system. It's so sickening. It's disgusting. But it just goes to show you all the contradictions there are within this system. It's so twisted and backwards. And the people who say, but we have the best system in the world, you say that because you're white and you like this system because it fits your little ego. It's actually a disgusting, evil system. And you support it. So I have to look at you side-eye. When it comes to cases on criminal issues from the United States Supreme Court, few cases are as ubiquitous as Miranda versus Arizona. However, Arizona has a prominent place in Fourth Amendment jurisprudence as well. Two 2009 decisions, Arizona versus Johnson and Arizona versus Gant, relate to vehicle searches, with Johnson dealing with stop and frisk as it relates to passengers. Johnson specifically allows an officer to frisk a passenger if there is reasonable suspicion that the person is armed and dangerous, while Gant held that the search of defendant's vehicle was unreasonable while he was handcuffed in a police car after he voluntarily left the vehicle and the search was not directly linked to the arrest. So you see, they can't just go and do things wrong, yet police officers will do these things. Although numerous states have adopted different versions of the stop and frisk, there also has recently been elevated controversy about the practice. Recent decisions also raised the question of where the pendulum currently stands in relation to the policing strategy. The American Civil Liberties Union, ACLU, studied stop and frisk data from New York City, where the practice has been used heavily as crime has reduced steadily over the last 2 decades. It found that more than half of those detained and searched were black and another third were Latino, all while the policy had a marginal effect on the number of robberies and burglaries. A 2013 decision in the Southern District of New York found that New York's stop and frisk policy violated the Equal Protection Clause of the 14th Amendment. Judge Shira A. Schindlin went so far as to call it a, quote, policy of indirect racial profiling, unquote. After stop and frisk encounters increased from approximately 100,000 in 2002 at the beginning of Mayor Michael Bloomberg's term to 700,000 in 2011, the practice was curtailed drastically. Judge Schindlin's decision and Bill de Blasio's election as mayor reduced the method's use as a crime prevention tool, as Terry only allowed its use for officer safety. While stops were reduced to around 10,000 in total, the number of murders fell as well. The 291 murders in 2017 was the lowest number recorded in New York City since the 1950s, seriously challenging the theory that stop and frisk was reducing crime. So you see, again, they were using nothing but shenanigans and their own stereotypes to justify the actions of this unlawful, this very unjust law that they want to put in place and keep in place, and that they have in place and support. But yet there's data that seriously challenges it. The theory that stop and frisk was reducing crime when the numbers just don't prove that. But yet you have these white racists and these white tyrannists and terrorists who call themselves Americans parakeeting this very nonsense without the data and without the information and facts. They're always running their mouths about what they don't even know what they're talking about. That's what they usually do most of the time. And unfortunately, the black community in particular, you believe their shenanigans. You believe they're half-truths and flat-out lies. And the bad thing is that other people, and I'll use this term loosely in this video because I very rarely will use this term, but the other people of color also get to hear the facts instead of going around repeating like parakeets what the white terrorists and the white tyrannists who are suffering from a white inferiority complex, they're going around spewing their half-truths. Now they have to deal with the facts. In comparison to New York, Arizona gives people the right to respond to police questioning with much less substance. Unlike Arizona, which only requires a person to identify him or herself, New York also requires an explanation of the person's conduct. In short, Arizona gives law enforcement little more authority to ask additional questions once a person is detained based on the reasonable suspicion standard. When prosecutors evaluate their cases, Terry is just one of the many areas of law that have to be considered. The impact overall is that officers must focus on articulating the facts effectively in their reports so that all facts are preserved in order to defend any challenges to the stop. And this brings up a good point. This is why it's so important in the many racial profiling cases and especially the killings of unarmed black men and women across America. This is why it's so important for officers to put it in all the facts right away and not give them any leeway to like 24 or 48 or 72 hours before they have to comply and write up a report or respond to an act that they've done. It is so important for that to be done right away when all the facts are preserved in their memory bank right away as it just happened. That's why you know that when they call for those other types of shenanigans for police officers to get away with delaying responding to whatever they've done wrong, it seems that our law officials have a blind eye. They want to give the officers a little leeway, give them time to come up with their lies. And that's where it must stop. I think it's important for police officers in every situation to report their facts right away as it happens. Right away as you have the facts. Especially if it's a high profile, very high important type of situation. That's very important. But I digress. It is one area where the needs of the case may in fact be more important to manage when it comes to the safety of the officers. It is easy to take an academic view and require every detail from the officer. but in order to maintain a sense of cooperation with policing agencies, prosecutors have to walk a fine line in educating officers while still being willing to take on the tough arguments in worthy cases where the facts are not all a prosecutor would wish them to be. So, in other words, if you just heard that, what I just read is that basically prosecutors want ideal cases that they can definitely win. And it's very sloppy when these police officers don't report the facts properly. We know that from Johnny Cochran, and may he rest in peace, because in this report I have a question, a very important question. Where are the Johnny Cochrans of 2018 when you need them? And may the real Johnny Cochran rest in peace. But where are our Johnny Cochrans? Where are our black lawyers, our top black lawyers challenging these issues? I don't hear from them. They seem to be silent. Where are they? But I digress. So both prosecution and defense have to review their cases carefully. Officers are looking at the real life scene and what is safe at the time, while in effect the legal teams engage in a fairly academic review of the situation. Terry simply provides the framework within which each legal team works. Now, I'm going to tell you what's so foul about this situation that I just read on the Stop and Frisk, the 50th anniversary of the Stop and Frisk, Terry Frisk law. You know, I've read several times, and you heard me read about the safety of the police officers. I don't get that when the police officer is armed with the weapon. The police officer is usually the ones who are armed and dangerous. Secondly, every time that I read about some of these stories written by these people who think in a Eurocentric valued system, they always speak on that certain tone about the safety of the officers. Again, when the police officers have the weapons, they also talk about the safety of the officers when the safety of the officers' concerns really should be the safety and concerns of black people across America, because remember, you are here to protect and serve. And if that's the case, and if that's a fact, people, the police are not doing that to black people. There's a problem within this system, and it needs to be addressed properly. And that's what this video is about. This video is about this 50 years of Stop and Frisk. And I learned quite a few things from this. And by the way, I want to give credit where